I'm going to start with just a brief intro on who Beth and I are, so you can know why we're qualified to talk about what we're going to discuss today. But I think you all know this is Workplace Investigations 101. And as I said, for those of you who missed it, I was just saying that the PowerPoint and the CLE, the actual presentation, will be up on the website. You'll get early access to that if you fill out the feedback form, but the whole thing will be up for the general public in a few days. So I'm Diana Maier, and I've been practicing law for about 18 years, 15 years in employment law, which is really the area of law that workplace investigations falls under. So I have been doing employment law for a long time. I've done it from both the plaintiff side, and now I do exclusively defense side. So I work with employers, but I did a lot of plaintiffs work for years. That was all I did. So I do know that side and what leads to complaints in the workplace, and the perspective of the employee as well. So that does come in handy for this talk. And I'm also a privacy attorney. Also, I do speak Spanish, and I can conduct investigations in Spanish, so that can be a really helpful thing to know, because a lot of times people are looking for Spanish-speaking investigators, and there's not that many of them out there. And I have with me Beth Arnese, who received her JD from UCLA Law School in 2005. So she's been practicing for about 11 years now, and she joined me in 2016, the very beginning of the year. And Beth has specialized in litigation and employment law throughout her tenure as an attorney. She also knows privacy law, and she also conducts workplace investigation. Okay, sorry about that, guys. So here are the things we're going to talk about today. When to investigate, thank you. How to prepare for the investigation, how to interview, so just some tips that have come in handy for us, how to prepare a written report, and what to do after the investigation, next kind of steps that you should take once it's concluded, and then general best practices of an investigation. So when do you need to conduct a workplace investigation? Well, there is an absolute duty to investigate, meaning law, it's codified into law essentially, either in clear language in the law or by interpretation via cases later on, that there's a duty to investigate whenever there is some kind of actionable conduct in the workplace. And for those of you that aren't attorneys, the actionable means essentially conduct that could be litigated. So there's something in the law that says this kind of conduct is illegal. So those could be claims of discrimination, harassment, retaliation, and so on. Anytime something illegal happens or potentially illegal, you do want to look into it and find out what happened and see if there's something that you can do to ameliorate the situation, and if there's anything you can do to prevent the situation. Here are areas where we suggest that you investigate, but they're not technically required. And that is in the case of demand letters. So you maybe get a letter and you want to get to the bottom of it and find out what's required. Also, in the case of lawsuits, is someone will send you a letter. You'll have a lawsuit, you'll have a complaint in front of you, and you want to get to the bottom of it. You want to know where your defenses lie and your affirmative defenses, and so on. And then things like theft, obviously, you'd want to investigate to get to the bottom of it. And I think investigating violation of workplace policies, if there's some ambiguity in the situation, I think that's always a good idea. I also really do advise it when someone uses the magic word. So for example, hostile work environment is probably one of the most misused terms in the English language. People think it's anytime there's hostility in the workplace, or there's an unfair boss or an unfair coworker, or they perceive abusive conduct, but none of those things are illegal. But if somebody says that and there's no protected class, involved, which is when it would in fact be illegal, but they just say there's a hostile work environment, it's still not a bad idea to investigate it, because you want to find out if in fact there is some, protected class involved, or there is some longer story here that might involve actionable conduct. It also does a lot to assuage the person making the complaint. So even if it's used incorrectly, it's a good time to consider investigating. So why do you have to investigate? Well, under California and federal law, employers have a legal duty to take all reasonable steps to prevent harassment, discrimination, and other unlawful employment practices. An investigation has just routinely been considered one of the best reasonable steps an employer can take to prevent illegal activity. So it's just a great way to send the message that you care, that you're trying to get to the bottom of it, that you plan to take action once you know what's happening. All those things. You want to make sure this hasn't happened to others or won't happen again. It sends all those messages. Also, there is some suggestion now that there's this case Trujillo, and there's also a federal case that suggests there actually is an independent cause of action for failing to investigate. Whereas, 12940 of the government code, which is the Fair Employment and Housing Act, says that you've got to prevent it, and then the cases just say that the way you prevent harassment or discrimination is through an investigation. There's actually cases that are a bit more explicit now saying that an investigation in and of itself can be required. So if you have knowledge of potential harassment or discrimination, an investigation is really the best way to go. And I would urge that this is the case even when you don't have a complaint that's submitted in writing or through HR or through the formal complaint process. In fact, when I edit sexual harassment policies, which I do a lot of these days, I often change the language. It describes exactly what you have to do to make the complaint. And I'll say, you go to a superior, but not like their direct supervisor, because their direct supervisor might be the harasser, or it might be someone they're not comfortable discussing with. So I try to write the policy so that it's as complaint friendly as possible. And so the employee can't say, well, I didn't complain because I didn't feel comfortable, or my options were too limited, or so on or so forth. So that's a really good thing to think about, is anytime somebody makes a complaint, that it gives it all the company a concern to investigate it. And don't forget that the duty to investigate can still be triggered with off-duty conduct. So if your off-duty conduct involves your employees and it's going to affect the day-to-day relationship of the employees, there may be times when it's perfectly appropriate to investigate what happened. And then there's also, of course, lots of times where there's an offsite event, but it's still really under the auspices of the company and the company's functioning, right? It's a chance for employees to bond and develop relationships. And that certainly is rife for possible later sexual harassment complaints. That's probably the most frequent one I get from those kinds of things. But there is a duty definitely to investigate in situations like that. So the bottom line is that it's almost always a good idea to investigate workplace complaints. You're going to get a lot of really helpful information. And, the biggest downside, obviously, to doing these is if you have an outside investigator, you're going to pay money. So you got to prioritize based on your budget, but you're really never going to get bad news, in the sense that even when you get bad news, it's going to be good for you to get it now as opposed to later. And let me go into this in a little bit more detail, but an investigation can help prevent or reduce liability for harassment. So the investigation can actually limit damages to the date employee made the complaint, because that's when the employer will know of it, unless, of course, there was a reason the employer should have known about it earlier. But that essentially will allow the period of liability to be reduced. And it also allows the company to say that they have a good faith basis when they take an action against the alleged wrongdoer. So if they have looked into, you never want to just get a complaint and take an action. You want to make sure that the person a complaint is being made against, that they've been given a chance to be heard as well. So, but if they have, and if the evidence comes down that actually they did do something wrong and you want to take an action, you can support that, as opposed to just basically taking the action on a whim or based on somebody's complaint that you really don't know much about the complaining person's credibility. And then finally, an investigation just gives you so much valuable information. You know, it can alert you to problem employees, practices that you might not be aware of, but that are concerning employees that you can head off at the pass. It gives you a sense of the current workplace climate and also other legal issues that might be brewing. I can't tell you how many times I've gone in to do an investigation and some other really big issue comes up while I'm doing it. So again, you know, no news is not good. The adage "no news is not good news" does not apply here. Any news is better than no news when it comes to investigations. What I would say. And the other thing that's wonderful about investigations is that an investigation can be used as an affirmative defense, or it helps establish an affirmative defense when there's two elements that are present. So if the employer has exercised reasonable care to prevent and correct any harassing behavior, and that, of course, the investigation is going to be key to doing that. And then if the employee has unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. One big caveat here, though, is if this will not apply if the employer has taken an action against the employee that's negative. For example, if they've demoted or terminated the employee, it's going to be too late to use something like this. But if they have not, and they can say these two elements are present, then this can be a really powerful tool to fight a claim. And if you don't investigate, the complaining party can suggest that you failed to prevent harassment or discrimination from occurring, and certainly if it were a particularly egregious case, that would be a very plausible thing to argue. And if you have a number of incidences that are not investigated, then that argument becomes quite powerful. As we said before, there is arguably an independent cause of action for failure to investigate, and there is certainly something under the Fair Employment and Housing Act that says that investigations are a key way to prevent harassment and discrimination. Finally, the lack of an investigation can make the employer look really bad, that they really didn't care what was going on, that they got the news, but they didn't look into it right away. And that can be used as a basis for punitive damages, or just to basically discredit the employer so that they might lose their case. So again, we're big advocates for doing investigations, but for the few times when it just seems that doing so is really not worth the money that you might spend on an outside investigator, or maybe the time and energy resources of an internal investigator. And I'm going to turn this over to Beth.
So many of you on the webinar listening now probably already know this, but in California, if you hire a third-party investigator to come in and do an investigation, that person has to be either a licensed private investigator or a licensed attorney. And when you have an attorney as an investigator, there are some key considerations that you need to keep in mind. First, realize that the investigator may be called as a witness. So for that reason, if you have an attorney providing ongoing advice and counsel to your company, you probably don't want to use that attorney as your investigator, and that's because he or she could be considered to be biased in the investigation. For these reasons, we always recommend that a company hire an attorney that they don't use for their routine advice and counsel. There are many attorneys throughout California who conduct workplace investigations. And another thing to keep in mind is that an attorney may lose the attorney-client privilege in the investigation. This is just something to consider as you go along. I think it's interesting to note that actually just this morning I received an update on a recent case that was, it's not published, but basically in that case, they found that the city of Petaluma hired an outside investigator who was an attorney to conduct an investigation, and the appellate court held that the investigation was privileged. Again, it's an unpublished case, so it's not a case that you could necessarily rely on, but I think it's safe to say there's enough kind of difference in opinion in that subject that it's something attorneys are aware of. Certainly investigators are aware of this, and something to keep in mind. If you have internal personnel conducting your investigation, then you have different considerations to understand. Internal company personnel are allowed to conduct an investigation, and in that circumstance, they're not required to be an attorney or a licensed investigator. If you are performing your investigation in-house, you need to make sure that the person conducting the investigation is truly neutral and also qualified to do the investigation. These are really important if the investigation proceeds to litigation and then you have somebody who's calling into question the adequacy of the investigation. So really take a look at whether your company has trained the investigator, or has the investigator completed training outside the company by a reputable investigations association. Does the in-house investigator have a relationship with or a connection to the individuals in the investigation? Obviously, you don't want the investigator to be friends with any of the people involved. You don't want the investigator herself to be involved in the underlying claim. So if you have a small company, I'd say this is more of a concern, but even with a larger company, before you begin the investigation, just make sure that that person conducting the investigation is truly neutral. Another thing that we recommend when you do have in-house individuals conducting the investigation is to have in-house counsel, if you have it, oversee the investigation so that you could claim privilege if needed. So when you have attorneys conducting an investigation, there are some ethical issues that come up that are important to note. If an attorney conducts the investigation, they could be prohibited from representing the client in a subsequent litigation because they might be a fact witness in the case. Obviously, that presents a whole host of issues that you don't necessarily want to get into. So for the reasons we previously discussed, it's always a good idea to hire kind of a neutral attorney who's not involved in your ongoing advice and counsel or your ongoing litigation. Attorneys who investigate do not have an attorney-client relationship with the witnesses. Attorneys should always advise the people that they are interviewing that they can't guarantee that the information discussed during the interview will remain confidential. So we like to tell people that the information will be kept as confidential as possible.
And I would just say here that, I do really bend over backwards to try and make my interviewees extremely comfortable. And for that reason, I will generally find out ahead of time who is going to get the report and how many people are going to see it. And who, and I will ask if it's okay to give that information to not the witnesses, but the interviewees, because I want them, because usually there is only one person, or maybe there's two people. And I also, whenever possible, will anonymize the information. So I'll say in my report, a witness said, or an interviewee said, as opposed to naming names. And I also check that out with the hiring company and ask them, are you okay with that approach? Because again, I want to make the interviewee as comfortable as possible. But what I do say to them is, if there's something that you don't want anyone to know but me, then it's probably not a good idea to tell it to me. But otherwise, here are the only people I believe will have access to this, and you will or will not be identified. So I do try and give them further assurances, but I am very clear about what I can and cannot promise.
So Diana mentioned at the beginning, we both practice privacy law as well as employment and investigation work. And so we thought that it's important to include a slide on some privacy issues that frequently come up in investigations. So one thing that investigators should do is they should document what they're doing in the investigation, specifically in terms of reviewing emails, voicemails, things like that. If you have to listen to somebody's voicemail just document what you're doing and why you're doing it. Companies should have policies stating that an employee does not have a complete expectation of privacy at work. That's a fairly standard provision to have in an employee handbook, but it's always good just to go back and confirm that you have that, particularly with respect to company email, voicemail, lockers, desks, etc. The policies should also say that the company has a right to inspect all company-owned equipment, anything created using company hardware or software, or anything created on company time. I think this provision is a little bit less common, so also a good thing to make sure that you have. This protects you a bit more when you come to an investigation and you need to access those various items. You need to have your investigator have access to them. So now kind of turning to the nuts and bolts of the investigation, the first step obviously is to prepare. And we've outlined some details on that. So a good place to start is by gathering documents, including any applicable policies and rules. This will be kind of an ongoing process depending on the specifics of your investigation. But I think at the outset, it's always a good idea to try to get a handle on what documents are relevant and to review them before you begin conducting interviews. You should have a contact at the company, someone who's not involved in the investigation, and you should work with that person to set up interviews. Another important step is to prepare a witness list. You will have a little bit of information at the outset, and you need to consider who you want to interview and in what order. Typically, we interview the complainant first and the alleged wrongdoer second, but that's not always the case. There could be circumstances under which you would want to switch the order.
And I'll just jump in here for a second, Beth, and say that one of those circumstances is when you can't get the complaining witness to actually talk to you. And so I, you know, in all the years I've been doing investigations, I've only had one case I can think of where I did not eventually succeed in getting the complaining witness to speak to me. But, you know, generally, I mean, sometimes it does take a while to convince them, and sometimes they have an attorney and you've got to contact the attorney. But it is always a good idea to do whatever you have to do to get that complaining witness to talk to you, because it is really hard to claim that you've done an accurate and full investigation without knowing what the complaining witness has to say. So in cases where that has come up, I try many different ways and modes, and I keep trying to get a hold of the complaining witness or to get her or him to talk to me before I'll give up.
Yeah, I think that's a really good point. And just kind of going back to the order of witnesses, we were saying that that's our typical practice, but the reality is it just doesn't always work out that way. One time I was working on an investigation with involving claims of a woman who had been terminated. So she was no longer at the company, and it took her a while to return my call. So in that case, I didn't end up interviewing her first because, as we'll talk about a little bit later, there is an obligation to conduct a prompt investigation. So that's something to keep in mind as well. You know, you're balancing lots of different considerations, and in the case that I was involved in, it just made sense to proceed with talking to other people first. So you should, in your preparation, you should prepare outlines of topics to address with the people that you're interviewing. You should determine the location of the interviews. We'll talk about that a little bit later. And then you should start right away. When you interview people, it's important to give them some admonitions. And kind of the standard set of admonitions that we give are on the following couple of slides. First, we give a brief summary of the investigation issue. The person that you're interviewing may not have any idea of the issue that's been raised. We also give them a summary of the process so they know what to expect. And like we talked about previously, we say that we'll limit disclosure to those who need to know, but we cannot guarantee confidentiality. Likewise, and this is a little bit complicated, but we do ask them not to discuss the subject of what we've talked about with anyone.
So, and I'll just jump in. here and say that, so there was a case, Banner, which was, there's a case that suggests that it's not a good idea to tell employees not to talk about something, but generally that is because the National Labor Relations Board will jump all over that and say, so for example, if you have a wage claim that's going on and you're investigating, you want to be really careful not to tell participants not to talk about the fact that, say, wages have gone unpaid or that there's off the clock time or something like that, because that does interfere with employees' rights to associate with one another. And the NLRB will be all over that. But I know investigators have taken that to the next level and said, well, we really shouldn't be asking people not to talk about this. But I disagree. I think the reason you ask people not to talk about it is because you want to keep the integrity of the investigation. If people start talking to one another about what they said, that biases witnesses and so on. And it also really inhibits other people from speaking freely to the investigator, which is the most important thing, I think, in any investigation, is to get as much information as possible and to get good information. So I think it is really important to give the admonition to not talk about the fact of the investigation or that this person spoke with you, or to let on other people that they think might be being investigated. But I do draw a line between saying don't talk about X or Y problem in the workplace and don't talk about the fact that there is an investigation about this problem. I think the latter is okay.
Yeah, I think that's a great point. So then another admonition that we think is really important is to explain that retaliation based on participation in the investigation is not allowed. This admonition works both ways. You're telling people, on the one hand, don't retaliate against anyone involved in the investigation, but also if you yourself feel that you've been retaliated against because you participated in the investigation, you need to let someone know right away so that the company can address that issue as well. When you're conducting your interviews, as you go along, you should always ask the witnesses who else would have information. Because as we talked about at the outset, when you're preparing and creating your witness list, it may not be a complete witness list. The person that gave you information at the company may not know that there were additional eyewitnesses or there are additional people that worked with the complaining party, just anyone who also might have relevant information that you might want to find out about. Again, you should remind interviewees that they should not retaliate because of the investigation, and they should report any retaliation that they believe they've been a victim of.
I just want to jump in here, Beth, and say if anyone has any questions as we go, please, I said this at the beginning, but I know a lot of people joined late today, so please go ahead and put your questions in the chat bar, and we'll try and answer them as they come up, as opposed to just taking all the questions at the end.
And then another consideration, something to think about before you begin interviewing really, is how you're taking notes. If you're doing that via computer or just handwritten in a notebook, I would say that's pretty much a personal preference. And then whether to record the interviews. We've kind of found that if you record the interviews, the people that you're interviewing seem a little bit more hesitant to share information with you, so we generally don't record the interviews, but that's not to say that that's a hard and fast rule. And if you do record the interviews, you need to get the consent of the person you're recording.
Yeah, I would say, if you use your recordings, great. I just found after many years, I was never using them. I do use them when I do an investigation in Spanish because I'm not a native Spanish speaker. I don't ever want someone to say, oh, she didn't understand. So I like to have the recording so that I can show, no, we were having a conversation. I clearly understood what was going on, and my questions and responses show that. But other than that, if I haven't used them up till now, I stopped thinking I was going to use them. So I only ask for consent and get it when I'm doing a bilingual investigation.
Great. And then in terms of kind of some interview techniques, how to effectively interview, we like to start with open-ended questions, and softballs are a good way to warm up. So ask about that person's background, kind of the easy questions, and then move on to the specific situation that's the subject of the investigation. You should probe witnesses with follow-up questions, asking about knowledge of any relationship between the complainant and the alleged wrongdoer. And I should note here, I meant to say this earlier, but this is the part that I think attorneys are very well trained and well versed in handling. You're going to have attorneys who are really capable of asking probing questions and getting additional information. And if you have an in-house investigator, we've just seen instances where that person wasn't as qualified or as trained in this skill, and so potentially missed getting all of the relevant information. Then finally, when you're interviewing, you should ask if there are other witnesses with information, find out if there are other documents that might be relevant to you. You should ask the person that you're interviewing if there's anything else that the investigator should know. Sometimes at the end, they may just have additions that for whatever reason weren't covered in your interview. So it's kind of good to just conclude with a follow-up question that allows for any additional information that you may have not discovered. You should also consider letting the complainant know that you will come back with the accused side of the story and ask them for follow-up questions so they don't feel like it's a case of the victim becoming the accused. And you should make credibility assessments. This is why it's always a good idea, although it may not be practical considering the circumstances, to interview in person. In terms of where to conduct the interviews, ideally you would be doing this in a private office. You don't necessarily want other people in the company to know who you're interviewing or even that you are interviewing people. However, in a lot of work spaces today, there may not be privacy in your office. You could work in an area without private offices or with offices that are all glass. In those circumstances, you should consider conducting the interviews off-site. So for note-taking during interviews, you should obviously take very detailed notes, but include only facts. For assessing credibility and other non-factual issues, use a different document. You should put the date on your notes and write down information about all the documents you provided to or received from the interviewees. You should consider taking notes for yourself on decisions about who to interview and not interview or other judgment calls you made during the investigation. And again, the reason for this is so that if the adequacy of the investigation is ever called into question, you have some record of why you did what you did, particularly if you're seeing litigation following the investigation. It may be, a year after the investigation that litigation is ongoing and people start to ask you questions about the nature of the investigation. And then for witness statements, if possible, if your witness is willing and if you have time, we think it's a good idea to confirm the accuracy of your notes and obtain the witness's initials.
So here are steps to take after the interview is done. Make sure that you've interviewed everyone that was important, with what they have to say. Of course, this is going to be a bit of a judgment call because investigations by outside investigators are expensive, but making sure that at least you can making sure you can at least pass the laugh test with saying this was a full and detailed unbiased investigation. So really getting kind of all the key witnesses on either side is critical, and then less key witnesses you can make a judgment call around. And then just consider where there should be follow-up. You don't want to just take what the complaining witness has to say for granted. You want to ask people about what that person said. And I think 100% of the time I have follow-up questions for both the complaining witness and the accused. So I actually try and warn them ahead of time that's going to happen, and that it's part of my job to be very diligent in this investigation and to kind of assess the credibility of everyone involved and not assume things are true. So I let them know that there is going to be follow-up to happen. And that way they won't claim they might claim, but in the beginning I would get, I would have someone would complain of sexual harassment, or she would say gender discrimination. And then I'd look into it. And a lot of people would say, well, that's not why such and such a thing happened. It happened because of this. And there'd be some other really big, smoking gun reason. Then I had to go back and ask the complaining witness, well, what about this big thing? And then she complained that, I was not taking her complaint seriously. So I try to give people a sense now ahead of time that I am going to come back to them, and it's nothing personal, that I do it in every single case, and that they shouldn't worry about it, but that they should know that that is something I'm going to do, so that I can say that I, did my due diligence and I followed up and I didn't just condemn the person that was accused. So someone asked if we take notes real time on a laptop while we're doing the interview, or do you take handwritten notes on paper? Or do you bring along another person so that the investigator can fully focus on the interview? I think it's a really good question. I mean, again, this is just going to be one of those things that is going to be a very personal practice. But what I have found is that I used to take handwritten notes, and now I type, because I type pretty fast. So I like to have the speed of typing. But it does usually require that whenever there's time and whenever possible, I go through at the end. Actually, both ways that I do it. I do need to go through at the end and go through my notes, usually with them there, so that, because there are always things in my notes that I have no idea what I was trying to say. And I often actually do catch quite a bit verbatim, but then I don't know what question I asked that led to that. So as I'm taking notes, I do try and write down my question so that their answer makes sense. There's some context to it. And then I try and write down what they wrote. And like I said, there's lots of times when I read through that I see that, that doesn't actually it's not totally clear here where we were going, or I get a portion of their answer, but I don't know what they're talking about. So revisiting it together is usually a good idea, because for one thing, it clears that up. But for another thing, it really allows them to see actually how much of what they've said I've gotten almost verbatim. And that's, usually just because the really key things they're saying I take down in quotes. And I'll slow people down. So, I mean, ideally, I'd love to take another person in, but I don't usually have the bandwidth to do that. And again, I now type because I type faster than I write, but I think it's really a matter of personal preference. Yeah, Beth's nodding, so she, I think, agrees.
Yeah, and I agree too, just for the record.
So, okay, moving on. So when do you want a written report? Well, this is kind of a tricky one, because there are a lot of good reasons to have a written report, and there's a lot of not so great reasons to have a written report. So, generally I would say that if the investigation shows that the company did everything pretty much right, a written report is going to be a helpful thing to have. It's a little trickier when the report shows some things that are really tricky for the company, that some things that the company didn't do so well. And of course there is privilege, but there have been some cases that have denied privilege, especially if the investigator is designated as an expert and they testify. So you just need to be aware that this is kind of a complex issue, and that, even if you have an attorney who's really mindful of preserving the privilege between you and between the company and herself or himself, that it still can be a tricky one. I do think a report can be really helpful when you're going to take an adverse action against an employee. And you are actually required to when that happens, to let the employee know you have to give them essentially a summary of the report so they have some idea why they're being terminated or, demoted or whatever. So, it's a really tricky call, and I would say that there's no one right answer. I think it really depends on what's going on, if you're involved in a lawsuit, if you're not, if you anticipate that you'll want to turn the report over, things like that. Things to think about in drafting the report. Well, outline all of the complainant's allegations. So one thing I always do is I say, I start out by saying, here are the things that I was looking into. And that actually is harder than it sounds sometimes, because a lot of times you'll get a handful of facts and then you do your investigation, you have a whole bunch of information, but it's not clear how to kind of break these down into concise kind of question and answers, because I'm asking the question, was there a finding of the following? And, I've got a whole bunch of things. And then my response is going to be yes or no. So trying to kind of take this information, break it down into findings is a little bit tricky. Adding to that trickiness is the fact that an investigator really should be focusing on facts. She is a neutral fact finder to the extent possible, an unbiased fact finder, and she is not coming to legal conclusions. That's what the counsel's for. But what she is doing is saying, yes, I think this happened, or no, I don't think this happened. But she's not expounding on, and that means the following. So that can be harder than it sounds, because sometimes there's a fine line between a factual conclusion and a legal one. But I would say, to the extent possible, stay clear of making legal conclusions. I do think sometimes it's really important to include your assessment of the credibility of the witnesses. For example, if you have 6 witnesses that all say the complaining witness is telling the truth, and one who says she's not, but you really believe that one who says she's not, then it's really important to explain why. And there may be a perfectly good reason that explains why you disbelieve 6 and you're okay with 1. And I just want to remind people to go ahead and, especially as I'm going through these sort of more complex points, to go ahead and send questions in via the chat. I think we talked about this, setting forth investigators' conclusions. As I said, getting all this into little sound bites of yes and no answers can be tricky, but I do think it's really helpful to break it down that way. And that is really what you're hired to do, is make findings of facts. And the other thing I would say is that I think another thing that is really important is using the preponderance of the evidence standard. So that's a civil standard that's used in civil court. So it's not the more likely than not standard, which is often described as a 90% likely to have happened. The civil standard is a 50% likely to have happened. So it's more likely than not, or less likely than not. And I don't use those words. I do have a footnote in my notes. I say it's the civil standard, it's more likely than not, which means it's 51% or more likely. And then I say it's unlikely, because I just find the language so confusing and not very helpful for my readers who are reading the report. I say unlikely if it's 49% or less likely. I mean, again, you're not gonna, usually you don't sit there and go, well, it's 40% or it's 86% or whatever, but you do have a sense a lot of times that, yeah, this just isn't flying in a way that I can feel confident is more likely than not, whereas, it would be, or maybe you're closer, but you know that a preponderance of the evidence standard, you would certainly not hold that there was a finding that something happened. And so you do have to think about how high is the standard, and therefore when you give your answer, do you want to qualify it at all and say, but I did find the following 6 things, even though my conclusion was that this didn't happen, I did find the following things did happen, which are important to know. And then you do really want to think about circling back with the complainant. Now, what you tell them is going to depend a lot on who you're dealing with, the sensitivity of what happened, how much you ratified what they had to say. You can probably tell them more if you ratified a lot of what they had to say. But you really want to stay away from giving them details. Again, it's protecting the confidentiality of people involved here, and being mindful of the fact that the complaining witness and the person who was responding to the complaint, the accused, they really don't want to know, and they shouldn't know kind of all the facts of the investigation, but they probably want to know in broad stripes what conclusion you came to. And I have a question. So the question is, if you're investigating the complaint of an employee and you've completed all of your interviews, and then that employee is laid off, so say for company business reasons having nothing to do with the complaint, during the course of your investigation, is your investigation and written report compromised if it's completed subsequent to that event? So this person's terminated and then, or excuse me, laid off, and then you complete the investigation. I don't think it's compromised. I mean, I guess there'd be some additional facts I'd want to know there. But I think if you've really asked all your questions, and you really feel that you've got a complete investigation, then no, I would have to say I don't think that it's compromised, or it's not compromised much, because I think the important thing is that you get all the questions out that you need to get out. Of course, what you do subsequent to the investigation is going to be very different in a case like this. But I don't think that just the fact that someone is laid off, changes the underlying substance of your findings.
Yeah, and I would just add that if you're dealing with a situation like this, I think you always, as lawyers, we're always advising people to have their decision-making process documented. But I think in this case in particular, you'd really want to make sure that whatever those company business reasons were, that they were very clear and documented somewhere, so that if there ever was an issue later on, the company could come back and explain, really this decision had nothing to do at all with the investigation. It was completely independent of that. And here are the various reasons why.
Thanks, Beth. So what corrective action should you take following the investigation? Well, one thing I will say is I think it's a really bad idea for the investigator to be involved in the decision of what to do. And this has to do, I think this is all the more important when you've got somebody in-house, right? Because you want to kind of have an ethical wall around that person who's doing the investigation, make them look unbiased. So you do not want to have somebody who's going to be a decision maker. But I don't think it's, and I do get asked to do it, and once I have done it, because I let them know I don't think this is a good idea. I think it compromises my impartiality, but they insisted, and I did give them some thoughts that I had. But the other thing is that you're not there. You don't know the context of what happened in a much broader context. You don't know anything about the employee's history. So I don't think you're the most qualified person, but I also just think it can be kind of a bad idea to do it, because it makes you look less impartial, or makes, if you're doing your investigation with an eye to, well, I'm going to recommend the following, that can compromise your investigation. And so you have to, of course, remedy the situation if you find that harassment or discrimination took place. And here's a couple of things. Maybe you're going to terminate the harasser or discipline. You can train them, you can give them counseling, transfer, demotion, reduction in pay. Basically, the cases say that what's appropriate depends on the circumstances, how egregious it is, past bad conduct, and so on. And then in terms of counseling, of course, that has to do with the employee. The employee that is the complaining person is going to have counseling. There certainly are times, actually, when you'd want to counsel the accused as well. But, paid counseling for the the accused, for the person making the complaint could be a good idea. And then, transfer is also something that you could use for the person making the complaint, but that has to be at his or her request. So you want to do anything that's going to make it look like you're retaliating against the person that made the complaint. So again, any action you take with respect to her or his employment, make sure it's requested by them. Things to think about is, has the company done something, what has the company done in the past in similar circumstances? So you want to go for consistency whenever possible. Has the alleged wrongdoer done anything similar in the past? And I think a really big one, and I think something employers look at a lot, and I think for good reason, is was the alleged wrongdoer truthful? Them coming clean and saying, mea culpa is, a lot of times employers are willing to be forgiving, but if they lie and they don't take any, and therefore take sort of zero accountability for the incident, then you might consider a stronger response. And of course, you want to look at how severe the actual underlying conduct was. You might want to look at if other people exhibited that conduct and what happened to them. So again, going for consistency to ward off any claims of discrimination. And is there anything in the company's policies about that? Multiple violations of company policy obviously should be taken more seriously than something that's not a violation of company policy and that's not illegal. So here's some options for the complainant: paid leave, company paid counseling, transfer, again, if they want one, a severance package with a release. Again, they have something they have to ask for. If they say there's just no way I can work with this person, and you really feel that terminating the person is the person who is the accused is really not fair or appropriate, then it may be that you need to give a severance to the person who's complaining. But I would say that it should be essentially, it should be sort of, you're pushed up against the wall, you have no other choice, and you bring it to the complaining witness and say, hey, how would you feel about this? And, we give you a generous severance package. I would certainly get a release in those kinds of cases. And you might consider counseling for medical bills and that kind of thing. So here are just some really quick best practices. You want to always make sure that you're thorough. And by the way, this is just taken from the key one or two cases that go through, what is a good investigation, essentially? What is going to be held to be adequate enough to defeat the failure to prevent discrimination and harassment claim, and so on. So it has to be thorough. You want to interview all the appropriate witnesses, get the key documents. You don't want to leave out any really material witness. You want to be prompt, and there is a lot of conversation about what prompt means, but basically there is no clear answer on it. Probably a month is too long. I mean, if there's reason for a delay, that's one thing, and that's understandable sometimes, and you just want to document it. But if you could get started right away, I oftentimes get called to do an investigation and the person wants me to start the next day, and maybe the complaint was made that day or yesterday. That probably doesn't need to happen, but in the following week is probably a really good idea if possible. There used to be a case that said a month was probably prompt enough, but again, I think it just depends. That could be too long depending on the circumstances. So I would say as quickly as you possibly can, without making yourselves crazy. You want to have the report be well documented. And so it's a good idea sometimes to get the notes together and keep those, especially if you don't have a written report. You want to protect confidentiality to keep the investigation unbiased and to keep the people involved and to protect their privacy. You want to communicate something to the victim and the alleged harasser or discriminator. So you want to get back to the victim and give him or her a sense of your findings, and same thing with the alleged harasser. You don't need to give them the actual report, but you need to give them some idea of what was found and what's going to happen. And then, of course, if you did find something wrong occurred, you do need to take corrective action. That's going to be a really important part of showing you took the complaint seriously. And you have to be unbiased. You do not want to have a case where somebody makes a complaint and you accept the complaint as true, because even when you find that witness to be very credible, you want to do whatever you can to corroborate this complaint. You just never know. And I've had a number of cases where I have investigated claims of sexual harassment, and looking into it, it is far more complex than that. But sometimes there's even coercive behavior alleged, and I look into it, and I just don't find that. So here are some good resources for you. And again, these slides will go up on the website so you can look at it. I've done a whole bunch of articles on investigations that you can look at on my blog. SHRM, the Society for Human Resource Management, is a great place to get pointers. And then also AOWI, which is the or it really goes by AWI now, is the only actual association of investigators, and they're a great resource for best practices, and they have all kinds of trainings as well and conferences. And finally, if you want to contact Beth or myself, here is our information. You want to email Lauren, our paralegal, your bar number, lauren@dianamirlaw.com. And like I said, after the presentation, you'll get a link to a page where you can give an evaluation of the presentation. Then you'll get your bar number, and you'll get access to the slides and to an audio of today's recording. Well, both an audio and a visual portion. Basically, you'll get access to this exact presentation. And that will go up for everybody within a few days, but we try and give first dibs on that to those that are willing to, fill out the review of the presentation. So thank you so much for listening, and we hope you'll join us in the fall on our next presentation, which we think is going to be on HIPAA. So we'll move into a privacy topic for the next one. And again, if you have any questions, feel free to reach out. And thank you so much for coming today.